Hello, my name is Mike Hayduck. I work in the Department of Insurance, Office of State Fire Marshal, Engineering and Codes Division, Engineering Services Section, administering the Code Officials Qualification Board education programs. I am not an attorney, and nothing I have included in this presentation is intended as legal advice or interpretation of law. This course simply presents the provisions of the new Chapter 160D Local Planning and Development Regulation that was created by Session Law 2019-111 with an original effective date of January 1st, 2021. Session Law 2020-3 delayed the effective date until August 1st, 2021 due to the COVID-19 coronavirus pandemic emergency. However, Session Law 2020-25 made the effective date retroactive to June 19, 2020, but provided a grace period for final adoption by local governments until July 1, 2021. This is a law and administration type course that provides 1 hour of continuing education in any trade for code enforcement officials. Why is this important? For code enforcement officials, the reason is consistency. From authorities having jurisdiction to authorities having jurisdiction. For the state of North Carolina, it probably facilitates economic development policy. The trend in local government has been toward including the building permitting and inspection staff within the Planning and Development Department to allow one-stop service to customers. The Session Law 2019-111 legislation is 129 pages. The SB 355 in parentheses on the slide means Senate Bill 355. By show of hands, how many code enforcement officials have read the entire Session Law? Great, then you can answer the 100-question written test that will be handed out during the presentation, but don't leave until you finish. By the way, the test is essay, not multiple choice. All right, did that get your attention? Just kidding. The short title of the law is An Act to Clarify, Consolidate, and Reorganize the Land Use Regulatory Laws of the State. That is why the 1-inch binder that the North Carolina Administrative Code and Policies Code comes in is too small. Get a 2-inch or 3-inch binder and put the session laws in there. Or you can use the CEO ID System Login Supplemental tab and look for the SL course where we are keeping track of the session laws. You all know that there have been 2 separate state statutes that set forth the duties of inspectors, one for city and one for county. The session law repeals both of the existing Chapter 153A and Chapter 160A and adds a whole new chapter, 160D, Local Planning and Development Regulation. As a result of this, there will be some changes to the board's Law and Administration course, North Carolina Administrative Code and Policies, etc. There are 3 parts to the session law that was approved July 11, 2019. Part 1, provisions to clarify and change the land use regulatory laws of the state. Part 2, provisions to reorganize, consolidate, modernize, and clarify statutes regarding local planning and development regulation. Part 3, the effective dates. The original effective date was January 1st, 2021. Then Session Law 2020-3, short title, An Act to Provide Aid to North Carolinians in Response to the Coronavirus Disease 2019 COVID-19 Crisis, reflects quick action by the legislature in May 2020 to address practical difficulties with implementation. Part 6 extended the effective date of Chapter 160D to August 1st, 2021. Session 2020-25 an act to complete the consolidation of land use provisions into one chapter of the General Statutes as directed by Session Law 2019-111 as recommended by the General Statutes Commission. The interesting thing is that this session law made the new Chapter 160D effective date retroactive to June 19, 2020. Confused? One of the main issues for compliance is the need for local governments to adopt their own ordinances. Therefore, the legislation provides for a grace period until July 1, 2021 to allow extra time for local governments to update their ordinances in light of the current difficulties caused by COVID-19 and allow others the option of exercising the new Chapter 160D immediately. Fortunately, there is an excellent blog by David Owens of the UNC School of Government that explains in great detail what is going on. Coates Canons, NC Local Government Law, Chapter 160D now effective. Part of this article is probably worth mentioning here. The General Statutes Commission staff had begun work on its required report and legislative recommendation in early 2020. The Commission met monthly through the spring to discuss draft legislation to integrate Part 1 of Session Law 2019-111 and other relevant 2019 legislation into Chapter 160D. Key parties who were engaged in the 2019 legislative debate, including the NC Home Builders Association and the North Carolina Bar Association's Zoning, Planning, and Land Use section, actively worked with the Commission and its staff throughout the spring. At its May 1st, 2020 meeting, the General Statutes Commission approved its report and draft legislation on this issue. The full General Statutes Commission report is posted here. Note, this report is 71 pages and includes the final draft of Chapter 160D. The General Statutes Commission was created by the General Assembly in 1945. The statutory provisions relating to the Commission are found in Article 2 of Chapter 164 of the General Statutes. The UNC School of Government has developed some workshops for local governments. Have any CEOs attended these? From what I see on the website and city and county managers listserv, these courses may be oriented more towards elected officials, town managers, and assistant managers than toward code enforcement officials. There are several videos on this site for further information. Why is a new Chapter 160D needed? Fortunately, the session law includes the reasons for this change as a series of findings. The General Assembly finds that a coherent organization of the statutes that authorize local government planning and development regulation is needed to make the statute simpler to find, easier to follow, and more uniform for all local governments. The General Assembly finds that the parallel system of separate city and county statutes regarding planning and development regulation has led to redundancy and unintended differences in the wording of planning and development regulation statutes on the same subject. The General Assembly finds that numerous specialized statutes affecting local planning and development regulation have been added in disparate chapters of the General Statutes over past decades, and that antiquated and confusing language exists in the planning and development regulation statutes. The General Assembly finds that, other than collecting some of these statutes into Article 19 of Chapter 160A of the General Statutes in 1971 and Article 18 of Chapter 153 of the General Statutes in 1973, no comprehensive reorganization of North Carolina's planning and development regulation statutes has been undertaken. The intent of the General Assembly, by enactment of Part 2 of this Act, is to collect and organize existing statutes regarding local planning and development into a single chapter of the General Statutes and to consolidate the statutes affecting cities and counties. The intent of the General Assembly, by enactment of Part 2 of this Act, is to neither eliminate, diminish, enlarge, nor expand the authority of local governments to exact land, construction, or money as part of the development approval process, or otherwise materially alter the scope of local authority to regulate development, and any modifications from earlier versions of Part 2 of this bill should not be interpreted to affect the scope of local government. So again, to recap, the new Chapter 160D replaces the two separate statutes, 153A and 160A, for cities and counties. The new Chapter 160D has 14 articles. This 50-minute CE presentation covers those articles that are most important to code enforcement officials. On this slide, Article 1, General Provisions, and Article 4, Administration, Enforcement, and Appeals, are in bold. However, inspectors who wear several hats, including minimum housing, nuisance abatement, zoning, or other planning functions, should read all 129 pages. Of the remaining articles listed, Article 11, Building Code Enforcement, is the other portion of the law we will cover. Article 1, General Provisions, includes some definitions you need to know. Development: the construction, erection, alteration, enlargement, renovation, substantial repair, movement to another site, or demolition of any structure. The excavation, grading, filling, clearing, or alteration of land. The initiation or substantial change in the use of land or the intensity of use of land. Definition of development regulation: a unified development ordinance, zoning regulation, subdivision regulation, erosion and sedimentation control regulation, floodplain or flood damage prevention regulation, mountain ridge protection regulation, stormwater control regulation, wireless telecommunication facility regulation, historic preservation or landmark regulation, housing code, state building code enforcement, or any other regulation adopted pursuant to this chapter, or a local act or charter that regulates land use or development. Note: state building code enforcement is specifically listed here and is bolded for emphasis. Something else of note as an editorial comment: cell phone tower site plan approval and permitting at the local government level has been a contentious issue for years. The issues related to aesthetic impacts, microwave radiation, and co-location on water towers, special and conditional use permits, you name it. My understanding has been that the only way to increase capacity of the network, meaning increasing the number of calls that can be handled, is to increase the number of towers. With the advent of 5G, this issue alone probably was a good reason to consolidate city and county planning and development regulations. This is a map of verified and unverified cell phone towers in the Triangle area on cellmapper.net. This map shows all the city and county corporate boundaries in the same area. Put yourself in the place of a telecom company trying to apply for site plan approvals and permits in hundreds of jurisdictions, each with their own development regulations. For example, some jurisdiction planning zoning boards of adjustment have required camouflaging of cell phone towers to make them blend in. This is an example of a cell tower disguised as a tree in Volcano National Park, Hawaii. Types and duration of statutory vested rights. Code enforcement officials are taught that a building permit expires 6 months after issuance unless work under the permit has commenced, and that building permits expire if no work is done for a year after it starts. Adam Lovelady of the UNC School of Government wrote the following for a Legislative Research Committee on Property Owner Protection and Rights in March 2014. A vested right is the right to continue a use or complete a project as it was approved, despite subsequent changes to the ordinance. Vested rights are founded on fairness and balancing interests, the public interest in uniform current rules, and private interest in protecting good faith investments in property development. The general rule is that new regulations apply equally to all properties. There is no right that generally applicable rules will remain unchanged forever. In some specific situations, however, vested rights protect those property owners who have relied on specific approvals from the local government. As stated before, basically the statute 160A for cities plus 153A for counties equals the new chapter 160D. Article 11, Building Code Enforcement, includes everything you are used to, with a few exceptions. You need to refer to Article 4 for the financial and stop orders provisions. The next group of slides compares the existing statutes to their new location in 160D. One impact of this new Chapter 160D is that the North Carolina Administrative Code and Policies Codebook, Chapter 2, Administrative Policies, cites the existing general statutes relative to the code sections. This code will need to be amended by the Building Code Council and reprinted. For example, Section 204, City and County Government, addresses inspection department administration duties, qualifications of inspectors. Note that 11-2, Building Code Administration, still includes the provision in the event that any local government fails to provide inspection services or ceases to provide such services, the Commissioner of Insurance shall arrange for the provision of such services either through personnel employed by the department or through an arrangement with other units of government. On this slide, I want to remind CEOs of some recent session law requirements that continue in the new Chapter 160D. 11.4 includes the requirements that each inspection department shall implement a process for informal internal review of inspection decisions made by the department's inspectors. And if a specific building framing inspection is required by the North Carolina Residential Code for 1- and 2-family dwellings, results in 15 or more separate violations of that code, the inspector shall forward a copy of the inspection report to the Department of Insurance. 11-5, other arrangements for inspection states, quote, a local government may contract with an individual who is not a local government employee, but who holds one of the applicable certificates, or with the employer of an individual who holds one of the applicable certificates. How many jurisdictions have enough inspectors? How many jurisdictions have used the inspector marketplace to make sure they have enough inspectors? This is the link for the inspector marketplace that is on the website. CEOs for hire. If you are a retired inspector and looking for work, maybe get this license plate. There are 3 questions to the survey: contact information, trade and level certificates, preference for plan review or field inspector. There is a separate link for the AHJ to look up the list of potential inspectors. That's the Inspector Marketplace CEO list. The password is Albemarle, which is also the name of the building in which the NCDOI and OSFM are located in Raleigh. Albemarle is the password. As of July 31st, 2020, there were 212 inspectors in the marketplace. You can see that about 70% hold Level 3 certificates and about 20% hold Level 1 and 2 certificates. The new 160D 11-7 mutual aid contracts is about establishing interlocal agreements with other jurisdictions. Contact Mike Hayduck if you would like sample agreements. Quote, any 2 or more cities or counties may enter into contracts with each other to provide mutual aid and assistance in the administration and enforcement of state and local laws pertaining to the North Carolina State Building Code. Unquote. 11-8, conflicts of interest, has gotten some attention lately in areas where code officials may also be licensed home inspectors. Staff has had some inquiries as to whether the code official's qualification or home inspector licensure boards have issued any guidance on this. All inspectors should read the statute language that states, in part, no member of an inspection department or other individual or an employee of a company contracting with a local government to conduct building inspections shall engage in any work that is inconsistent with his or her duties or with the interest of the local government, as determined by the local government. The local government must find a conflict of interest if any of the following is the case. 11-10 Building Permits is an important statute because it contains exceptions to the requirements for permits. It is time well spent periodically reading this, especially because it is subject to change by the legislature at least twice a year. For example, everyone should be aware that the cost of work exempted from permits was increased to $15,000 in any single-family residence or farm building unless the work involves any of the following. Many departments have permit techs that issue permits. Have they been to the law and admin course? Are they certified by the Q Board? How do they know what the statute requires? Another example from this statute is that, quote, a local government shall not require more than one building permit for the complete installation or replacement of any natural gas, propane gas, or electrical appliance on an existing structure when the installation or replacement is performed by a person licensed under General Statute 8721 or General Statute 8743. The cost of the building permit for such work shall not exceed the cost of any one individual trade permit issued by that local government, nor shall the local government increase the costs of any fees to offset the loss of revenue caused by this provision. Of course, 8721 is the State Board of Examiners of Plumbing, Heating, and Fire Sprinkler Contractors, and 8743 is the State Board of Examiners of Electrical Contractors. In light of the new Residential Changeout Inspector Certificate, that is a multi-trade, how will AHJ administrative procedures change? 11-13 Inspections of Work in Progress. I underlined this one because it has been the subject of some prior statutory changes and some controversy among code enforcement officials. This statute reads, quote, subject to the limitation imposed by General Statute 160D-11-4D, as the work pursuant to a building permit progresses, local inspectors shall make as many inspections thereof as may be necessary to satisfy them that the work is being done according to the provisions of any applicable state and local laws and the terms of the permit. What is the limitation imposed by 11-4D? Except as provided in General Statute 160D-1115, General Statute 160D-1117, and General Statute 160D-1207, a local government may not adopt or enforce a local ordinance or resolution or any other policy that requires regular, routine inspections of buildings or structures constructed in compliance with the North Carolina Residential Code for one- and two-family dwellings, in addition to the specific inspections required by the North Carolina Building Code, without first obtaining approval from the North Carolina Building Code Council. The North Carolina Building Code Council shall review all applications for additional inspections requested by a local government and shall, in a reasonable manner, approve or disapprove the additional inspections. This subsection does not limit the authority of the local government to require inspections upon unforeseen or unique circumstances that require immediate action. In performing the specific inspections required by the North Carolina Residential Building Code, the inspector shall conduct all inspections requested by the permit holder for each scheduled inspection visit. For each requested inspection, the inspector shall inform the permit holder of instances in which the work inspected is incomplete or otherwise fails to meet the requirements of the North Carolina Residential Code for 1- and 2-family dwellings or the North Carolina Building Code. End quote. CEOs may recall this and another provision, quote, the making of any necessary inspections in a timely manner, end quote, also implemented through Session Law 2015-145, Part 1, Section 1A and 1B, and Part 8, Section 8.1 and 8.2. These changes became effective October 1st, 2015. In addition, Session Law 2018-29, Section 2C, amended Chapter 143, Article 9, General Statute 143-139.4, certain building inspections by state, which became effective August 1st, 2018. Quote, Paragraph A. When a permit holder has been informed by a local inspection department that any inspection has not been or will not be conducted within 2 business days after first requested, the permit holder may request in writing that the commissioner assign personnel to conduct the inspection. The brouhaha surrounding these statutory changes includes the Building Code Council position that Section 107, Inspections, List of inspections of the North Carolina Administrative Code and policies, were the maximum number of inspections allowed. A pre-final inspection, which many AHJs required and performed, is not included on this list. Section 107, Required inspections from the general list. Optional inspections is one not on the general list, and which are not mandatory, but the jurisdiction can allow it. So if it's optional inspection for an open floor inspection, you can always request that inspection. Jurisdiction can say no, we don't have time to do it. They can say we'll be there. They can charge. There was a big discussion about this. This clears it up. Also a partial inspection. They can call it a partial framing, partial plumbing. Can always do that. Required inspection. Inspections on the general list of Section 107.1 of the North Carolina Administrative Code and policies, Section 107.1, which are mandatory if requested by a permit holder. Optional inspection. Inspections not on the general list of Section 107.1, which are not mandatory, but which the jurisdiction may allow if requested by a permit holder. Additional fees may be required for optional inspections, as approved by the AHJ. If a code violation is found during an optional inspection, then the inspector shall verify that the violation is corrected. Partial inspection. One of the inspections on the general list of Section 107.1, for which the permit holder makes multiple inspection requests of the same type and which are allowed by the AHJ. Another item of note is that appeals of stop orders is in Article 11, but stop orders are in Article 4. Administration, Enforcement, and Appeals. 11-16. Certificates of compliance includes a statement, quote, a temporary certificate of occupancy may be issued permitting occupancy for a stated period of time of either the entire building or of specified portions of the building if the inspector finds that the building may safely be occupied prior to its final completion, end quote. Session Law 2019-174, Section 5A and 5B added Paragraph B to 423 and 363. A permit holder may request and be issued a temporary certificate of occupancy if the condition and requirements of the North Carolina State Building Code are met. 11-18. Defects in buildings to be corrected. To me, this is one of the most important statutory requirements for code enforcement officials to remember because it clearly states the duty to notify the owner or occupant in order to protect the public. Quote, When a local inspector finds any defects in a building, or finds that the building has not been constructed in accordance with the applicable state and local laws, or that a building, because of its condition, is dangerous or contains fire hazardous conditions, it shall be the inspector's duty to notify the owner or occupant of the building of its defects, hazardous conditions, or failure to comply with the law. The owner or occupant shall each immediately remedy the defects, hazardous conditions, or violation of law of the property. These are existing statutes for 160A and 153A and the new 160D. These are more existing statutes for 160A and 153A and the new 160D. 1126 Records and Reports. The Inspection Department shall keep complete and accurate records in convenient form of all applications received, permits issued, inspections and re-inspections made, defects found, certificates of compliance or occupancy granted, and all other work and activities of the department. These records shall be kept in the manner and for the periods prescribed by the Department of Natural and Cultural Resources. Periodic reports shall be submitted to the governing board and to the Commissioner of Insurance as they shall, by ordinance, rule, or regulation, require. This is the website for the State Archives, and it includes the Municipal Records Retention and Disposition Schedule. You can see local government schedules are circled on this slide. The 2012 Local Government Records and Retention Schedule, Standard 5, Building Inspection Records, states most of these records are to be kept for 6 years. There was a 2016 amendment to the local government standards, but it was to Standard 6 and 9, not Standard 5. So this slide is an example of how long most records need to be kept. This last slide shows 11-28 fire limits and 11-29 with mention of a public officer. Discussion of these two items is beyond the scope of this presentation, except for a few comments. This statute provides for county fire limits that may include only business and industrial areas. No frame or wooden building or addition allowed except upon the permit of the inspection department and approval by the Commissioner of Insurance. Municipal fire limits, including the principal business portion of the city, known as primary fire limits, and one or more separate areas in the city as secondary fire limits. Similar to county fire limits, in the primary fire limits, no frame or wooden buildings. If the governing body fails to establish and define municipal primary fire limits, after call to their attention in writing by the Commissioner of Insurance, the Commissioner shall have the power to establish them. The term public officer is defined in Part 6 of Article 19 of North Carolina General Statute 160A. That definition says that it applies only to that part. However, the term is used all throughout 160A. In Statute 160A 4424 this is under Part 6 of Article 19. Public officer is defined as the officer or officers who are authorized by ordinances adopted hereunder to exercise the powers prescribed by the ordinances and by this part. So perhaps this definition of public officer in Part 6 of Article 19 of North Carolina General Statute 160A was modified slightly to apply to the whole of that article of 160D. Article 4, Administration, Enforcement, and Appeals, has a few statutes code enforcement officials should know. First, we'll talk about 160D-4-2, Administrative Staff. Of course, local governments still have authority to hire and appoint staff. I thought it was interesting that administrators, inspectors, and enforcement officers are listed separately. The duties listed cover all the functions related to development regulation. A development regulation may require that designated staff members take an oath of office. What do you suppose the significance of taking an oath of office is? This statute also includes provisions for alternative staff arrangements. This seems to address the Joint Inspection Department authority from earlier statutes and allows for one jurisdiction to designate staff from another jurisdiction to serve as members of its own staff. Also, a local government may contract with an individual, company, council of governments, regional planning agency, metropolitan planning organization, or rural planning agency to designate an individual who is not a city or county employee to work under the supervision of the local government to exercise the functions authorized by this section. The local government shall have the same potential liability, if any, for inspections conducted by an individual who is not an employee of the local government, as it does for an individual who is an employee of the local government. The company or individual with whom the local government contracts shall have errors and omissions and other insurance coverage acceptable to the local government. If you are familiar with the inspector marketplace or the residential changeout inspector legislation, this may be of interest to you. When an inspection, for which the permit holder has paid a fee to the local government, is performed by a marketplace pool code enforcement official upon request of the insurance commissioner under General Statute 143-151.12 9a, the local government shall promptly return to the permit holder the fee collected by the local government for such inspection. This subsection applies to the following types of inspection: plumbing, electrical systems, general building restrictions and regulations, heating and air conditioning, and the general construction of buildings. Another statute of interest in Article 4 is 160D-4-3, Administrative Development Approvals and Determinations. Inspections. This is the authority to enter upon premises at all reasonable hours pursuant to a permit or warrant. Certificate of occupancy. No building, structure, or use of land that is subject to a building permit required by Article 11 of this chapter shall be occupied or used until a certificate of occupancy or temporary certificate pursuant to GS 160D 11-14 has been issued. Enforcement. 160D-4-4. Enforcement includes notice of violation and stop work orders. Along with notice of defects discussed earlier, notices of violation are among the most important duty of a code enforcement official. It matters who and how people are notified. Meet or exceed the legal requirements to avoid process arguments. The notice of violation shall be delivered to the holder of the development approval and to the landowner of the property involved. If the landowner is not the holder of the development approval, by personal delivery, electronic delivery, or first-class mail, and may be provided by similar means to the occupant of the property or the person undertaking the work or activity. The notice of violation may be posted on the property. Stop work orders. The order shall be in writing, directed to the person doing the work or activity, and shall state the specific work or activity to be stopped, the reasons therefor, and the conditions under which the work or activity may be resumed. A copy of the order shall be delivered to the holder of the development approval and to the owner of the property involved, if that person is not the holder of the development approval, by personal delivery, electronic delivery, or first-class mail. 160D-4-5 Appeals of Administrative Decisions. This statute refers all appeals to the Board of Adjustment by default unless a different board is provided or authorized by statute. Course completion. Thank you for attending this online Code College course. If you wish to receive continuing education credit toward your Code Officials Qualification Board certification, you must successfully pass a separate quiz activity with a minimum score of 70%. After successful completion of the quiz and affirmation that you completed this course by yourself, CE credit will be applied to your Code Officials Qualification Board education records. You may access the certificate of completion for the course through your online account. Please take the opportunity to complete the course evaluation survey. If you have any questions about this presentation, please contact customer service.